Be seated. Before we go on the record, does IT, can you confirm that we are streaming and recording? We're ready to go. And does anybody have any audiovisual questions before we start? All right. If we don't, good morning. We are now on the record, and I'm convening the hearing on the unanimous settlement agreement in KCC docket number 23, EKCE 775 RTS. My name is Andrew French. I'm chair of the Kansas Corporation Commission. I'm joined by my fellow commissioners, Dwight Keene and Annie Keither. Representatives for the parties to this case are with us in person here in Topeka, but to those of you participating or watching online, welcome. Please bear with us if we experience any technical issues. I'm going to begin today's hearing with the entries of appearance by each party, and I will begin with Evergy.
Thank you, Chairman. Glenda Kafer and Trevor Wolford with Morris Lang Law Firm in Topeka, Kansas, on behalf of Evergy, and Kathy Dingus, in-house counsel with Evergy, is with us as well.
Thank you. I will go next to AARP. I believe they are online.
That's correct. Good morning. John Kaufman on behalf of AARP.
Thank you. Good morning. Next, for the Kansas Industrial Consumers Group, the Kansas Chamber of Commerce, and the Johnson County School Districts.
Good morning, Commissioners. Happy to be here today. Last Friday was the first day I've been in this room since March of 2020. So I'm happy to be with you today. Jim Zakora on behalf of KIC, the Kansas Chamber, Wichita Chamber, and the Kansas Schools. And with me today are Dan Buller and Lee Smithyman.
All right. Thank you. Good morning.
Thank you.
Next, we have the Climate and Energy Project. I believe they're online as well.
Yeah, good morning, Commissioners. Flynn on behalf of the Climate and Energy Project.
Good morning. Next, for the Natural Resources Defense Council, I believe also online. If you are speaking, you're on mute. It would be Mr. Titus, I believe. All right, we'll move on. I'll ask for NRDC again at the end. Department of Defense.
Mr. Commissioner, Kevin LaChance on behalf of the Department of Defense and all federal executive agencies in person. Online is Mr. John J. McNutt, a U.S. Army Legal Services Agency, and he'll make his own appearance, I believe.
All right, good morning, thank you. And just a reminder to those online, if you're not speaking, please mute your microphones. Next, we have USD 259 in Wichita, and I believe they are remote as well.
That's correct, Mr. Chair. It's Tim McKee and Casey Mays on behalf of USD 259. Thank you.
All right, thank you. Good morning. Next, for CVR Refining.
Good morning. May it please the Commission, Frank Caro and Jared Jevons with the Polsinelli Law Firm, appearing on behalf of CVR Refining.
Thank you. Good morning. Now for Holly Frontier Sinclair, Kansas Gas Service, and Atmos Energy.
Good morning, James G. Flaherty, Ottawa, Kansas, appearing on behalf of the intervener, HF Sinclair, El Dorado Refinery, LLC, and James G. Flaherty and Robert Elliott Vincent on behalf of the gas utilities, Atmos Energy, and Kansas Gas Service.
Thank you. Good morning. Now for the Streetlight Coalition, I believe they're online.
Yes, good morning, Your Honor. This is C. Edward Watson on behalf of the Streetlight Coalition. And also I'm on behalf of the Wichita Regional Chamber.
Thank you, Mr. Watson. Good morning. For Walmart online.
Good morning, Your Honor. Tim Opitz on behalf of Walmart.
Good morning. Citizens Utility Ratepayer Board.
Yes, Todd Love, appearing on behalf of the Citizens Utility Ratepayer Board, along with David Nickel, Consumer Counsel, and Joseph Hastrad.
Good morning. And finally, for Kansas Corporation Commission staff.
Yes, Carly Massentine appearing in person and Walker Hendricks appearing virtually for commission staff.
Thank you. I believe that's the end of entries of appearance. Let me ask one more time if we have someone from Natural Resources Defense Council. Okay, it appears they have not entered an appearance. Let's move on to notice for this proceeding this morning. Does staff have a recommendation on notice?
Yes, staff has examined notice and recommends a finding that notice was proper. KSA 77-518 requires the commission to give reasonable notice of the hearing at least 10 days prior to its commencement. On May 18th, 2023, the commission issued a procedural schedule in this docket which established the date, place, and time for this hearing. The parties held a pre-hearing conference on Monday, October 2nd, to discuss the details of the hearing to take place today. And for these reasons, staff recommends a finding that notice was proper.
Thank you. Are there any objections to a finding of proper notice for this proceeding? Hearing none, I will find that notice is proper. The commission has jurisdiction over this proceeding at this time and place. We will now begin with preliminary matters, and before I turn to the parties for any from them, just a few notes on conducting this hybrid proceeding today with both in-person and online participants. First, as we've said in many of our previous proceedings on Zoom, if any party encounters any technical issues, please just quickly ask us to go off the record so we can resolve that technical issue, and then we can go back on. Second, witnesses participating by Zoom are asked to keep their microphone off when they're not scheduled to talk. For participants in the room, you should also keep your table microphones off until you want to speak. If you need to speak, be sure to turn your microphone on so everyone can hear you and the cameras can find you. When you're done speaking, remember to turn your mic back off. Third, if the commission needs to deliberate, we'll be going off the record and deliberating in private, and then we will return to the record. Finally, to accommodate our online viewers, please be especially careful to identify exactly what you're referring to when discussing pre-filed testimony and exhibits. And we'll do our best to display anything or share it on our Zoom screen if there is a need to reference a specific document. All right, let's move to some preliminary procedural matters. I understand, I've got a few things here. I understand the parties are going to move to admit all the pre-filed testimony into the record without any further examination of certain witnesses. Second, I understand that KIC has asked to not pursue its motion to limit rate case expense, and that CURB, who had supported that motion, also agrees that that is no longer an issue. And finally, I understand the parties are going to request to amend the procedural schedule to waive any post-hearing briefs. So I want to take up each of those in the order I mentioned them. So first, I'm going to begin with Ms. Kafer and Evergy. Do you want to present the motion to admit everyone's pre-filed testimony into the record?
Yes. The parties have agreed that I can make one motion on behalf of everyone to move into the record the direct testimony, cross-answering testimony, rebuttal testimony, and the testimony in support of the settlement agreements.
Okay, so we are including the settlement agreement testimony even for those appearing in person?
Yeah, I think there's a few who filed that type of testimony, but they're not, weren't planning to, so that probably is the cleanest way to do it.
Very good. Are there any objections to that motion? Hearing none, it is approved. All of the pre-filed testimony that's been filed in this docket is admitted and has become part of the record. Next, Mr. Zakura, can you confirm that KIC's motion on rate case expense is no longer being pursued?
Yes, that is correct.
Thank you. And Mr. Nickel, or Mr. Love, I believe, can you confirm that CURB's support of that abandoned motion is no longer an issue?
That is correct.
All right, thank you. Finally, I do understand that the parties wish to waive post-hearing briefing. If that's not the case, please speak up right now. And hearing nothing, I will order that the pre-hearing schedule is amended to eliminate post-hearing briefs. Are there any other pre-hearing or preliminary matters that we need to address? All right. Hearing none, we will move to the procedure for the hearing. I understand that only Evergy will be making an opening statement under agreement from the pre-hearing conference. After Evergy's opening statement, we will follow the order of witnesses agreed to at the pre-hearing conference. And I understand that at the pre-hearing conference, the parties indicated that they will not be making closing statements. So with that, we'll begin with the opening statement of Evergy. Ms. Kafer.
Thank you. Good morning, Commissioners.
Good morning.
Chairman. We're here today not to kick off an adversarial and costly rate case proceeding, but rather to present you with a proposed universal settlement that was reached after significant effort and compromise by the parties. Evergy Kansas Central and Evergy Kansas Metro filed cases as mandated by the merger order from 5 years ago after a 5-year rate hiatus. And while the term rate case can carry with it negative connotations, that's not the overall story in this case. I'm pleased to report that the settlement we've submitted for your consideration presents a rate decrease for the Metro customers, and it will allow us to do a number of other positive things for Central, Metro, their customers, and for the state of Kansas. The parties have agreed to allow me to present the settlement on behalf of all of us this morning. First, I'll review the settlement terms that are common to both companies. On overall revenue requirements is story of my technical life. I gave it to him because it always messes up for me.
If someone's got control of the slides on a computer, if you could advance them.
There.
And you may just need to orally ask for the slides to be advanced if our clicker isn't working.
Okay. So overall revenue requirement for Metro, the recommendations in the case ranged from Evergy's request for a net increase of $14.2 million to staff's low position, which was a net decrease of $53.3 million. The settlement is a net decrease of $32.9 million. Now, you can see on here that's about where CURB was, but otherwise it's a larger decrease than any other party recommended. So after 5 years of base rates that had already been reduced in 2018 as a result of the merger proceeding that was pending at that time, and then the return of savings to customers during those 5 years of over $62 million, Metro customers will now experience another rate decrease. For the Central customers, the recommendations ranged from Evergy's request for a net increase of $204.2 million to staff's low recommendation at $34.7 million. The settlement is a net increase of $74 million. Like Metro, Central customers received a rate reduction in KCP&L's 2018 rate case as a result of the merger, and they have had no base rate increase since that time. The settlement supports continued improvement of rate competitiveness, which was an overriding goal of Evergy in this case, as well as every other party that was participating in the docket. Evergy's regional rate competitiveness has improved over the last 5 years since the merger, as was promised in the merger, with the rate decrease here of 4.52% for Metro and a rate increase to Central that's only 3.55%. Our rates will continue to become even more competitive. In fact, if you approve the settlement as proposed, Evergy Kansas customer rates will have only increased 1% since 2017, a period of time where we've seen substantial interest rate and inflationary increases. Now, while there is no stated return on equity in the settlement, Metro will be authorized to use 6.8881% as its overall ROR for regulatory accounting purposes, and an ROE of 9.4% for purposes of the TDC filings that are required by the new TDC legislation that was passed by the Kansas legislature this year. For Central, the settlement sets an overall ROR for regulatory accounting purposes at 6.8923% and an ROE of 9.4% for purposes of Central's TDC filings. And in computing the revenue requirement that we agreed to, We used the depreciation rates that were proposed by staff for both Central and Metro, including the stipulated depreciation rate for the Persimmon Creek Wind Farm. We agreed in the settlement to establish an injuries and damages reserve and a storm reserve for Metro, similar to those that already exist for Central, and we agreed to continue those for Central. The settlement includes terms for the annual accrual amounts, including imposition of a targeted cap and amortization of current amounts over the cap for Central. We agreed to the SIP's cybersecurity tracker, that it should remain in place, and we set the terms applicable to its accrual amount. In addition, the settlement provides that the tracker will sunset at the utility's first rate cases that are filed after January 1st of 2028. The balances in the pension and OPEB trackers were agreed upon in the settlement, and Evergy agreed to drop its request that the pension tracker 2 balances be included in rate base for purposes of this settlement. The settlement also addresses the COVID accounting authority order, including Evergy's agreement to withdraw its request for inclusion of lost revenues in that order. It rebases the property tax rider and establishes the basis for the property tax balance to be used in future property tax surcharge filings for the time period that the new rates set in this case are applicable. There is also a list of regulatory assets and liabilities, and the applicable amortization periods are also in the settlement, including the terms for how any over recovery or customer credit would be treated in future rate cases. Tariff alignment between EKCE and EKM was one of the goals of Evergy in its application. The settlement improves and aligns tariffs between the two companies, so all of our Kansas customers are treated more similarly and can better understand the services and the rates that are applicable to them. Cost allocation. With the multitude of parties that were involved in this docket who represented nearly every class of Evergy's customers, you can imagine that there was a substantial discussion on how to appropriately allocate cost among those classes. Ultimately, 22 of the parties were able to agree on a fair allocation, with only 5 of the parties disagreeing. It was HF Sinclair, Safer Coalition, Atmos, KGS, and Walmart. They disagreed with the allocation for the reasons that are stated in their pre-filed testimony. But all 5 of them agreed not to oppose the settlement so that it could be considered unanimous under the Commission's regulations. Although we agreed upon a cost allocation among classes, the settlement makes clear that that acceptance doesn't indicate adoption or endorsement of any specific class cost of service methodology or approach. And finally, we also agreed to use Evergy's billing determinants for Metro and staff's billing determinants for Central to develop the rates for each class. We agreed to use Evergy's 12 CP allocator for the Metro TDC and staff's 12 CP allocator in Central's TDC. The settlement, I think you jumped one. The settlement recommends the customer charge for all residential customer classes be $14.25. So that keeps the Metro customer charge at the same level that it's at right now. It reduces the Central customer charge from $14.50 to $14.25. And this settlement is in the range of the proposals that were presented in the pre-filed testimony of the parties. Time of use rates garnered a fair amount of attention. The settlement provides for both companies' pilot voluntary TOU rate to be converted into a voluntary permanent rate schedule. It accepts certain other changes that were posed by Evergy in its application, including a move to a 3-period rate for Central in order to be consistent with Metro. It includes a more moderate peak differential 2-period TOU rate that will also be designed and implemented for both companies, consistent with the rebuttal testimony that was filed by the company witness, Brad Lutz. The companies will report semi-annually to the commission for 3 years on the performance of those voluntary TOU rates. In addition, we agreed to a budget for marketing and education for TOU that includes an annual cap on cost of $2.5 million for Central and $950,000 for Metro. We agreed that these costs will be accumulated in a regulatory asset as they're incurred and considered for recovery over an appropriate time period in the next rate case. Evergy also agreed in its next general rate proceeding that it would propose an optional non-residential time variant business rate, or in the alternative, it'll offer testimony updating the commission on its status regarding such rates. In the most miscellaneous category, the settlement includes an agreement on a residential battery energy storage pilot with EMB reporting to evaluate the success of the pilot and determine whether or not to move it into a full-scale offering in the future. It includes modifications to the demand service pilot as they were proposed by Evergy in the application. The settlement decreases lighting rates equally for Metro customers. For Central's customers, LED lighting will receive 25% of the increase. Non-LED lighting will receive the remainder. Rates for adder components common between LED and non-LED will be equalized. The company will then notify non-LED customers of the cost savings and benefits associated with adopting the LED lighting. But if customers remain on the non-LED lighting at the time of the next general rate case, Evergy will offer testimony in that case detailing a plan to proactively move customers to the LED alternative. The settlement recommends that the changes the company proposed to its general rules and regulations be adopted. In addition, Evergy agreed to consider aggregated billing for the parties or customers represented by the parties under its general terms and conditions, providing that it will be permitted for meters located at the same premise and served under the same rates. However, Evergy will retain discretion to reject aggregated billing if it's determined detrimental to allow it. There were some undisputed issues, proposals that were in Evergy's application that nobody took issue with. We specifically identified those proposals in the settlement and recommended them for approval. These included an agreement that all the rate changes occurring from this docket for customers will be implemented based on the customer's billing cycle date. There were some terms in the settlement that were applicable only to Metro or only to Central. Metro first, we dealt with the jurisdictional allocations issue. In the settlement, we moved in the direction of correcting the Kansas-Missouri jurisdictional allocation problems that we've been struggling with for decades. On the jurisdictional production allocator, prior to 1983, allocations in Kansas were based upon a 7 CP methodology, and in Missouri, a 1 CP. And in the 1983 case, Kansas moved even further away from the 7 to a 12 CP. In KCPL's 1985 rate cases in Kansas and Missouri, KCPL proposed a 4 CP demand allocator in both states as a compromise that would work in both jurisdictions. In response, Missouri moved off of its 1 CP to a 4 CP. Kansas did not change from its 12 CP. So since then, Missouri has refused to move further, giving as one reason the fact that Kansas had not come off its 12 CP in response to their earlier compromise from the 1 to the 4 CP. The settlement adopts an average of the 4 CP and 12 CP, which the company believes is a more accurate allocation methodology, and it will also help address Missouri's objection in this regard. It states that staff and CURB make a commitment to continue meeting with the Missouri staff, the Office of Public Counsel over in Missouri, as they did earlier this year, to work on this and try and develop a full resolution. We believe we can achieve that resolution, but if it doesn't happen, then the parties have retained the right to propose whatever position on this they want to in Evergy's first general rate case in Kansas after the next Missouri rate case. The OSS, or the off-system sales margins allocator, has also been a problem. The settlement replaces the unused energy, or the UE1 allocator for these margins, with a more appropriate energy allocator. Because of the different allocation methodologies used between Kansas and Missouri to allocate these off-system sales margins, Metro has been crediting customers with off-system sales revenues of about 107% of the actual sales. So in other words, what that means is that Metro has been losing money for years on its off-system sales when it should be a zero-sum game for the company. The severity of this problem was highlighted during the Winter Storm Uri. This allocation inequity resulted in Evergy having to credit $11.2 million more than it actually received in revenues. Adopting this energy allocator in the settlement corrects this inequity prospectively, and as part of the give and take of the settlement negotiations on the issue, Evergy agreed to forego recovery from Kansas customers of their share of that $11.2 million shortfall. Rate design for Metro, the settlement doesn't make any changes to the existing Metro customers classes, except for the addition of a large power class that resulted from the adoption of Bright Lines. And Bright Lines is a utility tariff application that establishes thresholds which define the utility classes. You know, what class does a customer belong in based upon that customer's usage characteristics. The company's proposal was to employ Bright Lines to bring consistency to how rate classes are defined across its jurisdictions and to minimize rate switching across classes. It benefits customers by stabilizing classes and facilitating more transparent and appropriate rate making. The settlement recommends approval of implementing Bright Line divisions between Metro's commercial and industrial customer classes, but to protect those customers from experiencing a major rate increase if they were immediately moved into a different rate class as a result of Bright Lines. In this settlement, we established parameters to alleviate those rate impacts while we transition customers to their more appropriate class and rates. On non-residential rate design, the parties agreed that the hours use approach for C&I energy charge should be replaced with the new energy charge calculation that was proposed by Metro in its direct filing as modified by Walmart's witness, Mr. Steve Criss. In addition, the hours use approach should be retained and applied to customers with net metering. The terms applicable only for Evergy Kansas Central. As you know, during the 5 years of the rate moratorium, the earnings reports filed by Evergy under the merger agreement showed that Central was always earning well below its authorized ROE of 9.3%. So after 5 years without a base rate increase, one was necessary. And as I previously explained, the compromise we reached among the parties lowered that increase substantially from what was supported by Evergy's application. The settlement offers other benefits to Central customers. It assigns two very attractive generation assets to the service of the Central customers, the Persimmon Creek Wind Farm and the Jeffrey Energy Center 8%. That's already owned by Central, but that 8% is not presently in its rate base. These assets are already operating and they're producing energy that's available immediately to Central's customers, and there are no construction or procurement risk associated with these assets as there would be with other resource options that are not already built or under contract. The Persimmon Creek Wind Farm, this is a newly acquired renewable generation asset that operates with a high capacity factor, a low levelized cost of energy, and it has an attractive congestion transmission profile. We've agreed on the rate-making terms for Persimmon Creek that ensure that customers will receive levelized cost and that they will be the ones that benefit from the production tax credit. After 20 years, the levelized revenue requirement will be reevaluated to consider any maintenance, capital expenditures, or cost for extending the life of the facility, and the levelized annual revenue requirement would also be reevaluated in the event that Central repowers the facility after the expiration of the initial production tax credit. On the JEC 8%, the settlement includes moving Central's existing 8% interest in JEC that's not currently serving retail customers into base rates, and then flowing any off-system sales revenue associated with the resource through the fuel clause for the benefit of Central customers. This coal-fired unit provides an economic and reliable source of dispatchable capacity at a cost to customers that's very attractive compared to other options. The company-owned life insurance, or COLI program, that has been scheduled to expire in March of 2025, at which time the credit in rates of over $40 million should end, which would cause a significant rate hike all of a sudden. Evergy proposed in its application to address this issue by spreading out the remaining amount of the credit over 4 years. So we could reduce the credit to $15.4 million for 4 years, and then after that time, it would terminate. Staff accepted the concept of spreading the credit out over a few years, but took a different approach in calculating what the remaining amount of the credit is. So in the settlement, we were able to work out terms and a process to transition the end of this 40-year program that results in a rate credit, in this case of $32.2 million for 3 years. And this, which provides the remaining COLI program benefits to the customer. It allows us to resolve the conclusion of this program, and it smooths the impact of the conclusion on the customers. The settlement gives Central the option of filing an abbreviated rate case if the circumstances support such a filing. It can include 3 items: system beneficial investments necessary to serve the new load for Panasonic and the surrounding service territory, the Wolf Creek Decommissioning Trust funding adjustment, if any, that may result from the pending triennial review, and then investment in new renewable generating resource to address the 2024 to 26 resource requirements that are supported by Evergy's IRP that was filed in June of 2023. The abbreviated case provides an opportunity for all of us to postpone incurring the additional expense of another full general rate case for the Commission's consideration of these limited items, because that's an expense that we have to pass on to our customers. So in closing, a few weeks ago, we had 27 parties in this docket with chasms between their positions on the various revenue and rate design issues. And if you would have told me then that we'd reach a global unanimous settlement, I would have said, yeah, right. But after 9 very intense days where people advocated for their constituents, but listened to the positions and concerns of other parties and considered those positions, we got there. What we arrived at is a reasonable resolution of the many issues and the varied positions that were represented in this docket. It's a fair outcome that results in reliable service for customers at just and reasonable rates. So on behalf of all the signatories, I ask that the Commission approve without modification the unanimous settlement agreement we present here today for your consideration. Thank you.
Thank you, Ms. Kafer. Well, since I understand no other parties are making opening statements today, we will move directly into the witnesses testifying on the settlement agreement, and we will begin with Evergy. So Ms. Kafer, you may call your witness.
Call to the stand Mr. Darren R. Ives. Good morning, Mr. Ives. Would you state your name and your position for the record, please?
Good morning, Ms. Kiefer. My name is Darren Ives. I'm the Vice President of Regulatory Affairs for Evergy, and I am based out of Evergy's headquarters in Kansas City, Missouri.
Can we have the witness sworn, please?
Oh, sorry.
Sorry.
I need to swear you. You solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
So same question, same answer, under oath? That's still?
Yes, ma'am.
Okay. We've already had your testimony. You filed direct testimony, rebuttal testimony, and testimony in support of the settlement. Is that correct?
Yes, I did.
And we've already had that put into the record, so that's unnecessary. I think I can just tender the witness for cross.
Yes. Thank you. So this is a bit different today. I understand under the settlement agreement, the parties have all agreed to waive cross-examination. So we will move directly into any questions that the commissioners have for this witness. And I believe I will start with Commissioner Keene.
Thank you. Good morning, Mr. Ives.
Good morning, Commissioner.
Just a few questions for you this morning, Darren. Obviously, by its nature, the settlement agreement represents a negotiated compromise of many issues. From Evergy's perspective, could you please address and share with us what you believe are the most consequential and specific benefits that accrue to Evergy from the terms of the settlement agreement?
Yeah, there are a number. I'd start where Ms. Kiefer discussed, bringing in the additional generating resources in central of Persimmon Creek Wind Farm and the Jeffrey 8% were important facets of our direct filing in this case, important to the continued growth and expansion in Kansas and our ability to serve customers reliably. So those are pretty significant. Ms. Kiefer also alluded to a big part of our rate design in this case was around aligning our general terms and conditions, a number of our tariffs, including a number of our rider tariffs. There's a handful of benefits to that. Certainly the most important probably is the benefit to Kansas customers and their ability to have very similar terms and conditions and tariffs in place between their friends and neighbors in Kansas. So easier to understand, easier to appreciate the similarities with other Kansans. Certainly a benefit to Evergy. Helps with our call center, helps with our customer communications, streamlines processes for us as well. So very, very appreciative of the parties' willingness to consider those moves and help us align those jurisdictions. On the central side, we were able to resolve a number of historical rate-making items that had been setting out there. The largest is COLI. COLI's been out there. It's a rather unique mechanism that was put in place in the 80s that's been setting out there, heading towards resolution, as Ms. Kiefer identified, and the parties were able to come to agreement on how to wrap that program up and provide the remainder of those customer credits to Central's customers and set a path for how we proceed coming out of that. Probably the last one I'd mention, we have a number, as the commission knows, a number of regulatory assets and liabilities that set out there as a result of commission actions over the years. There was a lot of movement between the parties this time on the amortization periods, the recovery periods. In order to accomplish that, which we were able to do, we put a tracking schedule in place that allows us to make sure that everybody's very clear what those terms are, what those periods are, and ultimately collects any over recovery by the customer or over return or over recovery by the company or over return to customers that occurs just because of the timing of future rate cases, and make sure that we have fair recovery that doesn't go to the favor of one party or another just as a result of the timing of rate cases. So probably many more, but those are the ones I'd highlight.
All right, thank you. And I don't intend, I'll say this for the record, Darren, to have you duplicate to any large extent the very fine opening that Ms. Kafer provided. But I think I'm kind of asking you and I appreciate the granularity of your responses as you characteristically do, to kind of fill in some of the specifics around some of these general areas. Well, thank you very much for that statement of benefits. That was an interesting list, to be sure. Again, by way of perspective, in its application, Evergy sought a net revenue increase of $204 million for Evergy Kansas Central and a net revenue increase of $14 million for Evergy Kansas Metro, for a total of approximately $218 million net rate increase. Under the settlement agreement, Evergy Kansas Central would receive a net revenue increase of $74 million, and Evergy Kansas Metro would receive a net revenue decrease of $32.9 million. For Evergy, would represent basically a net increase, if you combine the two, of roughly $41 million. So we have $218 million that was originally requested, $41 million net that was suggested, certainly under the settlement agreement. It's a pretty major difference. So my question to you is, given this circumstance and this really large difference, can you share with us which factors influenced the company's decision to accept the terms of the settlement agreement?
Yeah, it's a great question. As you noted, there was a pretty widespread of revenue requirements, with Evergy at one end of the spectrum, I would say staff at the other end of the spectrum, and kind of all the parties in between, with several, down on the half closer to staff's position. A lot of parties in the docket, very, very difficult to work through a case like this with 26 parties with very divergent needs and interest. A lot of interest in the state of Kansas for well over 5 years now around regional rate competitiveness and a number of topics that we've talked about here, have been talked about in the legislature, have been talked about in numerous public forums. I think when you factor all that together, along with the ability for Evergy to take the steps that we were interested in that I went through a little bit earlier, we found a spot that was going to result in a fair and reasonable outcome, a result that all parties could align with and get comfortable for their stakeholders as well. I mentioned in my testimony in support of the settlement two things that I continue to be interested in moving forward. We have some differences of opinion among stakeholders in the state of Kansas on some financial policies. We had numerous positions that varied in this case on return on equity, on the appropriate capital structure to support operations. I would say the things that result in ensuring the financial strength of Evergy in supporting reliable service to customers today in Kansas, as well as being available for economic development and future customers. We resolve those by settlement here. I hope we continue to work on that in the state of Kansas and make sure that we are aligned on doing the right things for Kansas from a policy perspective, part of which includes maintaining the financial strength of Evergy to be competitive with its peers to bring capital into the state to serve customers. The other thing that I have in my testimony that we spent some time on in this case, and I alluded to it, we have a number of items, COLE's one, but a number of other regulatory assets and liabilities that parties took more aggressive terms on recovery on in this case than we have historically had. Again, we were able to find a way to resolve that amicably between all parties in this settlement. I have some concerns that when you move around amortizations like that, you can create some unintended consequences between current and future customers. Because when you amortize off credits on an accelerated time frame, it's a great benefit for customers today and coming out of the new rates in this case. But those credits will expire earlier, and there will be higher costs for customers to bear after that point. So I want to continue to think about that and work on that with stakeholders and parties as we move through it and make sure we're keeping the right balance on that. I think the tracking schedule that I mentioned will help that, because now there won't be winners and losers from the timing of amortizations any longer. If there's $1 deferred, it'll be $1 that is recovered for customers moving forward. So a couple of things to work on from my perspective. I know we'll be able to do it. It's easier to work on some of that stuff, candidly, when we're not in a litigated case and we're all advocating for our stakeholders, but we can just collaborate and talk about best policy for Kansas. And that's what we'll start doing after we get past this case.
Well, thank you for the granularity of that answer. I appreciate it very much, Darren. If I were to draw a general conclusion from your answer to that question, in part it would be that, as with the other parties who were interveners here, so too was it with Evergy that there was compromise on all sides.
Absolutely. 9 hard days of compromise by a lot of parties. So I didn't get a chance to say it when I got up here, but super appreciative of the efforts of all the parties. And it takes a lot of time and a lot of willingness to listen and compromise to get together over 9 days of really hard negotiations.
All right. My next question presumes something I think that is in evidence, and that is that there's been a lot of interest in this docket statewide. And there remains a lot of interest in this docket to the present time. So I'm going to ask you a question I think that will help provide answers to some questions that I think are probably out there for a fair measure of this audience. And I think will probably help clarify what's happening today and what may happen prospectively going forward. As evidenced in this rate case, certainly with Evergy, we have a bifurcated process here, whereby 2 major Evergy operating entities, Evergy Kansas Metro on the one hand, Evergy Kansas Central on the other. Obviously, Evergy is the product of the merger of Westar and Kansas City Power and Light in 2018. So although these entities are now merged into Evergy, they're treated separately for purposes of determining their revenue requirements, their expensing issues, and indeed the ultimate rate outcome if the commission were to adopt the terms of the settlement agreement as proposed. Evergy Kansas Metro customers would receive roughly a 4.75 rate decrease. Evergy Kansas Central customers simultaneously would witness a 4.05% rate increase. Share with us, if you would, and for the ratepayers at large who may be listening in, what causes the bifurcated approach and the different results?
It's a great question. I'm glad you brought it up. Very difficult for our customers in the state of Kansas to understand a difference like that. You know, if you look back over history, Central and its predecessor companies have built their system to serve customers over 100 plus years. Same with Metro, built separately, both under the jurisdiction of the KCC, but built specifically to serve the needs of the customers that were a part of their company at that time. You know, different approaches to generation supply resources, different design of transmission and distribution, a large part through necessity, right? I mean, if you look at the wire side of the business, Metro is very concentrated around a major city in Kansas City and near surrounding areas. You know, Central spreads out through, you know, roughly half of Kansas. So you have a lot less density of customers per mile, both from a distribution and a transmission side, but you still need to have all of that infrastructure in place to move power to get to those folks. You notice that even in this case, we had a set of items in the Central case in my direct testimony describing our request that said historical item resolution, and they were based in the Central docket, and it was millions of dollars of annual impact. It was stuff like COLI, where Metro doesn't have a COLI program, but we needed to find a solution to wrap up the COLI program that resides in Central. Was differences in depreciation rates where Central had a bigger impact in this case from aligning their depreciation rates with kind of the current life of the generating assets to support their service. Metro did not have that life mismatch coming into this case between their rates and what the current expected life is. There were a handful of items like that just were different between the jurisdictions. Many of them we cleaned up in this case, many that will continue to manifest themselves over a few more years to come. You know, Central's a product of you know, a couple utilities, one, you know, based out of the Wichita area and one based up here in Topeka. They ultimately got to rate alignment a little over 20 years after they completed their merger in the 90s. So it's possible, and we made a lot of good steps in this docket to get a lot of the foundation laid, to get some consistency between the jurisdictions so we can continue to move towards alignment. But 100 years of investment and systems have created some differences that it will take some time to align.
Well, thank you for the granularity of that answer as well. I think it was Keynes who said in the long term, we're all dead. So we're hoping the long term for your reconciling all of these issues will be within the lives and being plus more than 21 years. I appreciate your answer, but I'm not going to let you off the hook.
Sure.
With some specificity, I would appreciate your addressing the question of what steps can or should be taken to reduce or eliminate these rate-related disparities going forward. And to what extent can these matters be expedited so that we have two large service territories, the metro area, the central Kansas area, which, as you say, encompasses a good chunk of the state, roughly half of the state, more than that in terms of population. After all, both are Evergy companies. They provide the same or identical services to customers and ratepayers who just happen to be coincidentally situated in different geographic areas. please?
Yep, it's a great question. There are probably a number of steps. I probably should have mentioned when I was given the last discussion, coming out of the 18 cases and heading into this, if you look at, I'll just talk about residential rates. If you look at residential rates, Metro's rates were higher than Central's residential rates. So they are closer together as a result of this settlement than they were before we got into this case. So that's a positive from a rate alignment standpoint. What makes it difficult when you have separate rate structures and separate rates is when you have disparities. When you move towards alignment, usually what happens, right? It's not unlike a negotiation. In this case, you kind of move to the middle. Well, that means one set of customers is going to benefit from aligning, probably because they're finding a way to use resources that this set of customers started to pay for. And one set of customers is going to come the other direction. So it becomes very complicated. One of the biggest, I wasn't a part of it, but as I understand it, one of the biggest differentials back in the Western Resources, North and South combination was, one of them had ownership in Wolf Creek, and one of them was more coal-based. And the folks that had ownership in Wolf Creek didn't want to take on the responsibility for more coal, and the folks that had more coal didn't want to take on the cost of nuclear that they hadn't been a part of early on. So, it's those type of policy and philosophical debates that slow the process a little bit. That said, we made a lot of steps in this docket to align the foundation to be able to do that. One of the things I'd bring up is bright lines. You heard the discussion of that in Ms. Kafer's opening. Having a determined set of usage and determinants that sets where you set in which class, whether you're a large general service customer or a medium general service customer, helps bring some continuity and some structure to the non-res classes, that when you start to look at alignment across the utilities, it's easier to see that alignment when you've got folks in kind of predefined customer classes. We've got to work on the solution for Metro. You heard about jurisdictional allocations. Metro serves both Missouri and Kansas. Metro is regulated, almost 50-50 between the KCC and the Missouri Public Service Commission. And if we start moving items in Metro to align with Central, we've got to figure out what kind of impact that creates on Missouri and the way they think about rate making for the other half of Metro's jurisdiction and customers. So we're in a great spot to start that process now that we've done a lot of this alignment. And I hope each time we see this commission, we'll be making the next step and moving closer and closer to ultimate alignment for Kansas customers.
Well, I appreciate that. I think it's hard to take any large entity and both of the predecessor entities as well as the current entities, Metro and Central. Pardon me. These are large operating entities, excuse me, and you can't turn them on a dime. However, that being said, I certainly do appreciate what I sense here as a commitment by the company to continue to address these issues, which I think are really quite consequential. I'll conclude my questioning of you with a very brief statement. Many of the historical and legacy issues that you've alluded to here, and there's a big one that still, it's amazing how the mind becomes focused on certain issues and will remain focused on those issues for decades. within, I think, the mind's eye of many customers within the old KG&E rate area. The amount of cost that they bore in the construction and development of Wolf Creek, which I think was part of that dissimilar product that came into being when Westar was formed, is still out there. And there's a concern. I hear about it anecdotally. What are you going to do about that? 20 plus years ago. I appreciate very much, Darren, your testimony. I appreciate your patience with my questions as well. I have no further questions of this witness. Thank you.
All right, thank you, Commissioner Keen. Commissioner Keither, do you have any questions for Mr. Ives?
I do, but they're sort of prospective, I think. I appreciate the questions from Commissioner Keen and the answers. But I hear alignment and fair and reasonable outcome, and I think about the abbreviated case coming up with Panasonic. And it's my understanding Panasonic will be paying for a great deal of their own use of electricity, but the case then does come to the consumer. And having just gone through this alignment and this rate case, I think, their ears are going to be pricked up for anything that might be called an increase coming down the road for what is going to need to be built in adjacent to that Panasonic. So you're obviously very keenly aware of this, and I just sort of like to hear your perspective of what's down the road, because I think clearly ratepayers are paying attention.
Yeah, thanks for the question. It's been a well-discussed topic over the course of this case, for sure. I probably take some blame for that from wording choices that Evergy utilized in describing the abbreviated case. Panasonic's a significant addition to not only the state of Kansas, but certainly to the service territory for Evergy as a customer that will ultimately need to serve. No doubt about that. But they are no different conceptually than any other customer that comes into our service territory and adds service. When customers come in, they pay for any investments that we make that specifically serve them. I think you alluded to that in your question, and that's certainly true for Panasonic. Stuff that we're putting in, substations, direct connect wires, will all be part of what gets paid for by Panasonic. There are other system investments sometimes that have to be made to bring a customer online and provide them reliable service. They're not just for Panasonic. They certainly are maybe accelerated on the system because there's new load coming into the service territory. But they're investments that are going to benefit kind of the greater area around DeSoto and into Lawrence and that area. Would have been on the schedule anyway with just natural growth in our service territory. Those are the type of investments that we're talking about with Panasonic to be considered for an abbreviated case. So they're system beneficial investments that, one, are going to get Panasonic online and give them reliable service, but are going to bring benefits to the broader DeSoto, Lawrence, surrounding area. That happens with all of our customers we bring online. This one's just a little bit bigger scale because they're a large footprint customer. And an abbreviated case lets us bring those investments in front of parties and in front of the commission in a more limited way based upon the rate making parameters that all the parties have just reviewed in this case. So it happens in a a less costly, quicker time frame for commission review. And we think that will be beneficial. Absolutely needed and necessary investments, not done on our own. We consult with, Southwest Power Pool. We consult with others about what needs to be done to maintain the system reliably for customers in the area. So a lot of input before we get to the Kansas stakeholders. We think we'll have a good demonstration for the commission and parties when we get to the point to bring those investments forward.
Thank you for that. I think you're going to have fun talking to the Kansas legislature about this because they're starting to hear that about the abbreviated rate case and they're saying, wait, that wasn't part of the agreement. So why this again? So I think you've laid the groundwork of working together, and I think that it's commendable. So thank you for your answer.
Yep, thank you.
All right, looks like it's to me, Mr. Ives. Good morning.
Good morning.
Well, you stole my thunder with my first line of questioning. I want to ask you about these amortization periods. And maybe I'm going to put it a little more bluntly than you put it. I was looking at the exhibit EKCE2, and you don't need to pull it up. I just want to talk generally about it. Obviously, you've got a big credit here with the COLI program, the corporate-owned life insurance program, and it's a big credit to be amortized over 3 years. So it's basically a $32 million credit each year, and then it drops off. But there's some other big credits and debits, go in both directions. But if I kind of back of the envelope add everything up, you've probably actually done that. I mean, it looks like at the end of a 3-year period, you've got like a $30 to $35 million credit dropping off, which is, this probably isn't your words, but it's almost to me like a baked in rate increase, or at least a big upward pressure on rates at the end of 3 years. Could you talk a little bit about why you all deem that to be acceptable, sort of the pros and cons of adopting a 3-year amortization period versus maybe a smaller credit over 6 years? What was the thinking behind 3 years from the company's perspective?
Yeah, so it's very insightful. It's something we did have some discussions on. From a company perspective, it's easy to work with COLI. So let's start there. Had we done nothing in this case, other than kind of follow historical practice over about 8 cases in front of this commission, there would have been about $41 million that would have been a credit in customer rates. And that credit would have expired in March 2025. So it would have been a very short turnaround before we would have had a $40 million rate pressure to address. And you summarized it well, right? I mean, when you look at the credit that results from those schedules at the end of 3 years, absent any other changes in relevant factors, which we all know nothing stays static for 3 years, right? But absent that, there would be, a rate pressure that would be faced, coming out of that 3-year amortization period. What we always advocate for is, evaluating kind of the appropriate time to look at those amortizations. Some of that evaluation comes from, well, how long were those funds collected? And is it reasonable to then, have customers recover them under, about that same time frame? Or is it actually an unusual or anomalous amount that you have to find a way to smooth that out and make it more palatable for customers in their rates? So it's a little bit of art versus science anyway. And we ultimately came down when we looked across that getting some consistency across the categories, made it very clear for all the parties of kind of the period under evaluation, putting the tracking schedule on top of it with that kind of helps all the parties understand that there aren't going to be winners and losers because of the timing of cases moving forward. We'll clean that up through future regulatory assets or liabilities. I think the combination of those couple things helped us get on board, and certainly it was an amount that supported rate outcomes in this case that a number of the positions in this case were lined up with.
Thank you. Appreciate that. Ask sort of a follow-on question that's related. You know, you said nothing stays static. There's always cost increases, cost decreases. I know, a major downward driver of staff's position in this case was when they did their update, and Evergy continues to gain savings from the merger, continues to find efficiencies, reduced cost associated with that. I guess I kind of want to ask what levers you all think you still have to pull to counter sort of the upward pressure that we just talked about on rates. Are there still more efficiencies to gain in combining the customers or in combining the companies? Or are we kind of at the end of that runway? Are there other levers that you have to pull over the next 3 years to try to mitigate that upward pressure that we're going to see at the end of that 3-year amortization period?
Yeah, it's a good question. We've had phenomenal success in the combination of the companies. When we came in front of this commission 5+ years ago, we said, well, look, we can get an aggregated savings from combining these companies of $620 million over 5 years. Through December of 22, which was 4.5 years in, we had reached almost $1 billion in savings from combination. So we've had really good success, better than we thought we could. It's a testament to our employees, to the innovation and the work that they've done to bring these companies together in every way possible, with the exception maybe of customer rates, right, which is much more difficult and kind of the end result of getting the operations pulled together. Are there more savings? I mean, the answer has to be yes. It's probably not going to be an aggregate, $1 billion over 5 years. I mean, we've done the heavy lift work, but it's our job and our responsibility to continue to evaluate our processes, continue to evaluate our company, seek best practices, not only amongst our legacy companies, but from benchmarking and learning from our peers and all the things that this commission would expect us to do. So I'm hopeful that we can continue to have some level of offset against rising costs. The flip side of that, as you know, we're in as high of an inflationary and interest rate environment than we've been in for a while. That pressures our business, just like it pressures everybody's personal checking accounts and balances. So we're going to have to navigate through that time. And we've presented in front of this commission a couple times, but we have a lot of infrastructure investment to make. We have aging infrastructure on the wires. We have, a transition that needs to continue to occur on our generation supply. It needs to occur in a balanced way, and we need to have kind of all above philosophy on our mix of generation, but it's going to have to occur, and that will cost money as well. We'll do it in a balanced way. It's in my testimony. It's in Mr. Campbell's testimony. Affordability, reliability, and sustainability are our focus areas. Affordability leads that discussion for a reason. It's important. We've got to balance all stakeholders' interest as we progress this utility to be able to serve Kansans for decades to come.
All right, thank you. Move to a little different topic here, but I'll stay on revenue requirement. Just a quick question about the JEC 8%, and I'm stretching my memory a little bit, but I think the last time Evergy sought to bring that piece of Jeffrey into its revenue requirement, I think they were going to sort of buy it for $1, and the big cost driver was more just the fixed O&M and of operating that. Is there any material rate base associated with adding the 8% JEC, or is it still just kind of the fixed O&M component?
It is primarily O&M. There is a little bit of rate base. Your memory is pretty good. There was an arrangement that was going to allow for this transaction to move forward without further commission determination if we were able to buy that facility for $1. We weren't able to get to $1. We've got to a very de minimis amount of cost to buy that 8% back. And so we did bring it forward, parties to that case. And ultimately the commission said, it's not the right time. You don't have, you can't demonstrate the need necessary for us to bring that 8% in. This time, and I appreciate staff's position on this, we can demonstrate a need. A couple of those things are a direct result of the merger again, right? I mean, we didn't used to have a visible integrated resource plan. That was one of the items that came out of the merger, was this commission wanted to start seeing integrated resource plans. Now we can all see the timeline and the need when we have to bring supply resources like this on. And so I think now is the time, and it will be primarily the O&M, which will be supportive of benefits to customers.
And as I understand it, the need to bring that on or to offer this resource to customers, it really has more to do with the capacity, resource adequacy requirements, the need to have backstop dispatchable capacity within your portfolio, not necessarily the need to run the plant more often, just the need to be there. But I guess getting to a question, when you knew you needed more of that type of capacity with the attributes that this has to meet your resource adequacy requirements, I mean, did you kind of look around in the bilateral market, and how did the cost of acquiring this compare to the cost of any other capacity available that would be deliverable to customers? Was there any readily available capacity that the company could have purchased as an alternative to this?
Yep, good question. We did. We absolutely looked at the bilateral market. We have run a couple rounds of requests for proposals for all sources. JEC is incredibly economical with where it sits right now because of that relatively low acquisition price to buy that out of the prior arrangement. That certainly helps. O&M is relatively cost effective compared to any of our current operating alternatives. And to your point, it's probably more geared towards the capacity side. So the O&M certainly will be less if it's not operating at a full capacity. But we looked at that. You won't be surprised by this, I don't think, but with the SPP market changes, the increase in the capacity reserves, the upcoming changes to accredited capacity for both fossil and renewables, the entire footprint is facing questions and facing concerns, and a lot less people interested in selling forward, medium to long-term capacity, because they've got the same questions we do with those changes.
Yeah, thanks. Appreciate that. Well, I've got one more line of questioning, and this is more rate design, and it's going to be even more general than my previous questions, but I want to talk just a little bit about time of use rates. I think, this has been of interest to us in Kansas, but we've certainly read the headlines and seen what the situation is in Missouri, moving toward mandatory time of use rates. We're obviously not going there with this settlement. It looks like you are going to expand your time of use offerings, and you're going to try to gain information. You're going to give us reporting, but if you're willing to share, it's not really fully laid out in the settlement. What is the company's view of the pathway in the future? Is the plan to open this up for hopefully greater adoption of time of use rates? Is there any plan to move toward more of an opt-out scheme after we've done a bunch of education? If you can share, what's the thinking of, after this runway of gathering data, what's the hope?
Yeah, it's a good question. We've had a lot of interest in our other jurisdiction on time of use over the last number of months. Our position has always been, at least as long as I've been involved with rate design activities, creating options for customers, options that give them the ability to have a rate that fits their lifestyle or fits where they want to go, right? Time of use is a voluntary permanent rate schedule is a great move in that direction, because if people have the ability to modify their behavior in periods that are peak and impactful to the company, then they can benefit from having time of use rates, no doubt. And that ultimately means the rest of customers benefit because we're pulling that usage off a peak, which would drive us to that next resource requirement, that new next resource need. We have not been supporters of direct flash mandatory default time use rates. We've been pretty clear about that, but Missouri set a policy that went that way. We'd like to continue to create options for customers in Kansas. We have a couple this time, right? We've gone with, I'll call it a higher differential 3-part time of use rate as the primary voluntary schedule for customers. At the request of staff and parties, we looked at the addition of a 2-part rate that is a more moderate differential, another way to give customers in Kansas an option of, if you're not sure you can change your behavior to an extreme amount, but you want to try a time of use and see if you can, start with that 2-part rate with that more moderate differential and see how that works out for you. So I hope we continue to provide options, continue to meet Kansans where their usage is and how it fits their lifestyle. That'd be my goal. I haven't asked all the folks at Evergy yet.
Do you expect it? I don't think it's written into the settlement agreement, but obviously you're going to get a lot of data in Missouri over the next few years. Do you expect that will be made available when you give us updates, that we could kind of see what a mandatory time of use data looks like?
Yeah, absolutely. I don't think there'll be anything, sensitive or confidential in that regard. It's a big part of the discussion we had probably throughout this docket with parties. We didn't do, I would say, an extreme shift in rate design, particularly the residential in our filing in this case, in large part because we do want to pause a little and see what happens over there, see what we learn, see how we evaluate the results of that. Hopefully that brings benefit to Kansas, where we can follow up in a case in the near term that leverages those lessons learned before we jump in Kansas.
All right, appreciate it. I don't have any additional questions. In the intervening time, have either of my fellow commissioners developed any new lines of questioning? Commissioner Keene?
Thank you, Mr. Chair. Just very briefly, following on the time of use colloquy that you've had with the chair, I'll just express a personal preference here. I thought that one of the important terms of the settlement agreement was the permanent voluntary time of use that was approached. And at least as I'm able to divine a bias that you have from your testimony, I share that bias because I think it provides, in terms of what I think you were stating, the ultimate options for the customers to decide basically what is most suitable for them. So just a comment for me. I appreciate that aspect of the settlement agreement. Anything further you'd care to add, you certainly may.
Yeah, one thing maybe I probably should have added when I was talking to the chair, I mean, the parties also agreed to a budget with some cap levels for education and rollout of the time of use rates. Those dollars will be captured in a regulatory asset to be considered later. Maybe the most important part of the TOU settlement, right? We need to have the right education, the right outreach to customers, the right tools in place so that when customers are going to make that voluntary election, they've got good information and good data and they can understand the most likely impacts to them. We're going to learn a lot from Missouri in that regard. We've been running education by fire over in Missouri, but we've done a lot of education over there and we've learned. We've really started to get a feel for what's resonating with customers. We're getting feedback from customers and modifying that. We'll be able to leverage all that as we work through these plans over here to roll out education and outreach in Kansas. So I think that's hugely beneficial, both from the party's willingness to consider that and the ability to leverage what's been going on over in Missouri.
Thank you for those comments. Nothing further for Mr. Ives. Thank you.
All right, I don't believe there's any further commissioner questions for Mr. Ives. Ms. Kafer, do you have any redirect questions for your witness?
Quickly. You were asked about the disparity between Central and Missouri and the amount of the increase and the decrease and people's concern over that. Can you give us a general idea of what the actual rate comparability is if the settlement is approved? If I have a house in metro territory, how does my utility bill compare to if I have the same house and the same usage characteristics in the central area?
I should be able to.
If you can't, I put you on the spot.
I can't seem to put my hands on that at the moment, but I would just say, back to where we were almost 2 pennies apart after the last rate case in 18 with Metro having higher rates. I've narrowed that gap fairly substantially with the outcome of this case upon Commission's approval. So we're pretty similarly situated between Metro and Central. You have a little bit of volatility in an all-in rate because you still have some differences in our fuel riders because of changes in mix, and that can move it over time. But from a base perspective, we're going to be substantially closer than we were before we got to this settlement.
And kind of a two-part question on the Panasonic related investment over there. The need to build that investment, I mean, that poses a pretty big benefit to central customers as well, does it not, in increasing usage in the area?
Yeah, absolutely. Panasonic is one thing, right? In and of themselves, they're going to be large usage, large benefit for central customers overall. But there are going to be additional adds in that area as a result of the build out of Panasonic in that area. tertiary businesses that are going to come in and want to be close to Panasonic. There are over 4,000 employees that are going to be employed over there that are going to add to that area, and all of that incremental load helps share the cost of the overall central system. So certainly a lot of benefits for central customers when you have that type of economic development.
So just timing wise, is there anything unusual about when you're faced with that type of growth in the future where the company would make the investment first and then reap the benefits?
Nothing unusual about it, other than maybe the scale, right? But always we have the obligation and the benefit of providing service to any customer that wants to come into our service territory. So, which means we have to have the infrastructure in place, and it has to be able to provide reliable service before that customer is ready to start taking that service. Your investment's always in advance of bringing new customers into the territory.
Okay, thank you. That's all I have.
I'm not seeing any hands up from my fellow commissioners, so Mr. Ives, I think that concludes your testimony, and you may step down.
Thank you, Chair. Thank you, Commissioners.
We will now go to Kansas Industrial Consumers, Kansas Chamber, and Johnson County Schools. And Mr. Zakura, you may call your witness.
Thank you, Chair French. I would call to the witness stand Mr. Michael P. Boyle. And I would please ask that he be sworn.
I'm sorry, we can't hear Mr. Zakora.
Thank you. Go ahead, Mr. Zakura, if you could repeat.
Certainly. I would call to the witness stand Mr. Michael P. Gorman, and I would please ask that the witness be sworn.
And if the court reporter could turn your microphone on before you swear him, that'd be good. There's a little gray button.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
For the record, would you please state your name, sir? Michael Gorman. And did you file pre-filed testimony on behalf of Kansas Industrial Consumers, Lawrence Paper Company, Goodyear Tire and Rubber Company, Occidental Chemical Company, Spirit Aerosystems, and Associated Purchasing Services Corporation on behalf of the Kansas Hospital Association? And was your direct testimony filed on August 29, 2023, your cross-answering filed on September 5, 2023, and your testimony in support of the stipulated agreement filed on October 3rd, 2023? Yes. If I may ask the chair, the testimony has already been admitted, correct?
It is already admitted, yes.
Okay. Then, in that case, I would tender the witness for commissioner examination.
All right, thank you. As stated, we are moving directly to commissioner examination, no examination by the parties, and I will begin again with Commissioner Keene if you have any questions for this witness.
Yes, thank you, Chair French. Good morning, Mr. Gorman.
Good morning.
I'm going to say at the outset here that I found all of your testimony, frankly, and your testimony in support of the settlement agreement to be quite informative and very interesting. I also found your summary testimony to be quite to the point, quite succinct, and yet analytical. I want to turn very briefly to page 3 of your pre-filed testimony in support of this settlement agreement. And it's not necessary that that be brought up on the screen. I will read into the record from page 3, lines 10 through 17. The question you were asking this pre-filed testimony is, does the settlement consider the parties' filings made in response to the company's claimed revenue requirement? That was the question. And your answer is, and I'll read this verbatim from lines 12 through 17. Yes, many parties addressed the company's claimed revenue requirement in this proceeding. The staff audit was very useful in that it provided thorough and detailed findings on the company's cost of service in this proceeding and represented a highly professional assessment of the cost of providing service to Evergy's customers. Staff's audit and financial report on Evergy for both EKC, that would be Evergy Kansas Central, and EKM, that would be Evergy Kansas Metro, were very helpful in the resolution of the revenue requirement findings in this settlement. Those are very interesting conclusions. And what I would ask you, Mr. Gorman, is this. Could you elaborate just a bit more on these conclusions? And if you would, share with us the extent to which the KCC staff audit and recommendations played a role, in your opinion, in the development of the final terms of the settlement agreement.
Well, all parties addressed the settlement from the standpoint of ensuring that the utility was allowed to recover reasonable and prudent cost of providing service. But the complexity of reviewing the company's cost of service filing was quite daunting. Many of the parties that offered testimony in this relied on experts like myself that periodically review the company's cost of service and do our best to catch up on the relevant factors addressed in the test year filing and the projections for test year pro forma adjustments. Staff had a unique perspective because they are more involved in the company's cost and operational procedures on a daily basis than are many of the other experts that participate in these rate cases. When I filed testimony, along with my team, we reviewed the company's cost of service in as most detail as we could. We made recommendations on issues that we were able to derive, which we found overestimated their cost of service, but we left a placeholder in it noting that other parties may find appropriate adjustments to cost of service, which upon further review by us in subsequent filings before this case, we may find to be reasonable, and KIC and parties may wish to adopt in our final position. That largely did occur after a careful review of the staff's audited filings in this case.
Okay. Well, I appreciate that insight very much. We can only guesstimate from our perspective all the machinations that occur during the process of the settlement and which portions of which testimony, what the relative weight is that each one bears in the final outcome. I appreciate your testimony very much. I have no further questions of Mr. Gorman.
Commissioner Keither, do you have any questions for Mr. Gorman?
Not at this time.
Good morning, Mr. Gorman.
Morning.
Good to see you again. The only thing I think I want to ask you about is, and this is something I kind of want to ask each of the witnesses, is that same question I asked Mr. Ives about sort of some of the short amortization periods that were agreed to, and the fact that it returns credits to customers pretty quickly, but we potentially are setting up some upward pressure on rates in just a few years. And if you could just speak specifically to your view of why the amortization periods that are in the settlement are reasonable, and then maybe more generally about how you view, adopting the lowest possible reasonable rates in the immediate case versus rate stability over a longer time. Any thoughts you'd have on either of those would be very helpful.
Well, I can offer you my perspective. Those aren't specific terms that were agreed to in the settlement by all parties. But the reason we thought that the combination of terms in the settlement were reasonable based on those factors and other factors include the following. Typically for amortizations, you look at whether or not it's a cost that should be amortized over the corresponding rate cycle or for some reason, some period beyond the impending rate cycle. We saw the utilities rate cycle from this point to being shorter going forward than it's been in the past because of the restriction on filing rate case based on the merger terms. So based on that expectation of when the next rate filing would be made by the company, we made a review and assessment of what we thought the amortization periods would be reasonable. We also looked at what the cost of service changes could be going forward. There are additional investments the company's planning to make for distribution wires delivery service and production resources. But we also outlook that there may be some additional revenue from new customers on the system at that time. So we think there's going to be some offsets from increased cost and increased revenue in terms of whether or not the rates that are being agreed to here will be more reasonable over a longer period of time. So from a macro perspective, that was kind of the assessment we made to determine that the rates that are being agreed to in this settlement are reasonable, not only for the next rate cycle, but over maybe a bit longer period of time.
So it's your view that the company may have some levers to pull, and you're going to want to watch closely what happens over the next few years to see if some of that upward pressure on rates could be mitigated.
Yes, we will. Yes. And, rate affordability is a major issue for all of my clients, and rate affordability allows us to argue that the company needs to manage its capital programs in a way that maintains high quality, reliable service, but doesn't spend more than is necessary for that purpose, because accelerating the level of capital investments will grow rate base faster, which is a major element which drives an increase in cost of service. So we will be looking at whether or not the company manages that rate-based growth in a manner that helps to manage rate affordability, manage rate-based growth with other objectives of the company, such as enhancing shareholder value by growing rate base as fast as possible, which in turn can grow its earnings and dividend-paying ability. So there's a real balance for the company in managing that perspective. There's a real target for the customers of the company to ensure that capital investments are managed in a way that is consistent with maintaining rate affordability.
One of the other pressures is obviously maintaining reliability, and Mr. Ives and I discussed sort of the tightening capacity conditions in the various regions. We obviously sit in Southwest Power Pool, but I know you're keenly aware of the Mid-Continent System Operator. How do large volume customers view this need to maintain capacity reserves and the cost that goes along with that versus the potential for outages if those reserves aren't available? I mean, is there a recognition that that's a cost that we need to continue to bear, and that there may be some need for investment to maintain those adequate reserves?
Yes. High load factor, energy intensive companies need affordable rates, but high quality, reliable service. So that the need to have production resources in place that are adequate to serve peak demand is critical. The pricing for use of those resources is also important to energy intensive companies and weather sensitive customers, because there are ways for customers to manage their load characteristics on the system that can mitigate the demands they're placing on the utility system, which in turn can impact the resource investment the utility needs to make in order to have adequate planning reserve capacity and the ability to deliver that capacity to end-use customers. Some areas that we're particularly focusing on is the movement for reduced carbon emissions and renewable resources that are needed to accomplish that objective. The actual qualifying capacity of those renewable resources in relationship to their nameplate rating capacities, and also the amount of transmission capacity that has to be made available for renewable resources in order to stay in compliance with Southwest Power Pools. The need to buy transmission capacity in line with the renewable resources nameplate capacity can be somewhat problematic. If that renewable resource has qualifying capacity, that may be a small percentage of that nameplate capacity going into planning reserve margins. The consequence of that is there could be an overbuild of transmission capacity in Southwest Power Pool, and all of that would need to be procured in a manner consistent with SPP rules by load-serving entities such as Evergy, which means prices for customers on transmission capacity may reflect a lot more transmission capacity than is really needed by the utility to maintain system reliability. So all of that we're monitoring. We're trying to be heard and are concerned about balancing the amount of resources needed to maintain high quality, reliable service with also a critical need to maintain rate affordability.
Yeah. You mentioned the ability of some large volume users to maybe participate in using their flexibility to maybe mitigate additional resource needs. I understand in this case, I think KIC advocated for the time of business, time of use rate that's going to be looked at and potentially proposed. Are there other programs that you'd like to see the company pursue in the future, perhaps expanded demand side management programs that could be offered to large volume customers? I understand not every customer is flexible, but for those that can participate, is that something you'd like to see in the future?
Certainly greater cooperation between the utility and customers on that objective. Typically for demand side management for large energy intensive customers is very complex and it can be industrial facility specific. And while utilities have very capable and very qualified engineers, they don't necessarily know how to operate industrial facilities. So a pricing structure that allows industrial engineers to do demand side management is more critical to ensure that industrial facilities can modify consumption behavior to make their demands on the utility system as efficient as possible is probably more important than getting utility assistance in that engineering process. As I understand it, utility engineering assistance for smaller customers on demand side management is very critical because they're much smaller. They don't have the same spend on energy efficiency and they don't have access to the resources that the bigger customers do. So utility offers very significant benefits to smaller users on demand side management. But other aspects on this pricing structure include aggregate billing for continuously integrated utility customers, that they can actually manage loads put on the utility across the system while synchronizing the needs of their own resources and operating performance, but can, in combination by managing those aggregate loads, reduce demands on a peak period for the utility system, thereby lowering their need for additional transmission and production resource capacity. If there's adequate pricing incentive that allows those customers to go through the operational complexities and incur the cost to coordinate those demands on the system, that is, there's adequate pricing recognition of it, then they're willing to undertake those costs and go through those protocols in order to realize the benefits of reducing their bill by lowering contributions to peak demands on the system. So that in combination with time of use, I would say are two of the low-hanging fruit objectives for a lot of energy intensive companies to improve the economics and the efficiencies of the demands they place on the utility system.
Is there additional, I guess, educational programs that utilities should be pursuing to provide this assistance to their customers? Or do you believe that's outside the purview of the utility? How do we get that coordination to happen more?
Well, for industrial facilities, I think there's a lot of interaction between the utility and their representatives already. So I think there's a pretty strong understanding. If there's a need for improvement communication in that regard, I'm not aware of it. But I think educating smaller users on time of use behaviors and the real benefit of installing a more expensive HVAC system as opposed to a less expensive one and reduce on-peak area consumption and how that higher initial capital cost will be offset by much lower operating costs later is something that I think the utility can add some real credibility to because they're not seen as a stakeholder in selling the more expensive HVAC system to the end-use customers and can verify the true benefits of operating savings that can be produced those types of investments. And that would extend all the way from small residential customers up to some larger commercial customers because the complexity of that type of equipment and the need to understand the pricing structure of time of use energy rates.
Thank you. I appreciate the opportunity to lean on your experience a bit. Have any of my fellow commissioners developed additional questions in the time that, all right. Any redirect from Mr. Zakura?
With permission of the commission, I have just a little bit, if that's okay. Mr. Gorman, do you recall the line of questioning from Commissioner Keene about the staff work and the work of others in this case?
Yes,
And when you responded to him, was your response including the large amount of discovery requests that were sent in this case by all parties?
yes.
Do you recall how many discovery requests were sent in this case?
I do not know. I know it was a very significant number of discovery requests.
You wouldn't be surprised if I told you it was about 1,000, would you?
I would not.
And Evergy did a great job in responding to those, did they not?
They did.
And between the staff, their rate-based adjustments, income adjustments, and 1,000 discovery requests, do you feel like there was a very thorough audit in this case of the operations of Evergy Kansas Central and Evergy Kansas Metro?
I do. I believe the company's response to the data request were detailed and complete, which allowed for a very careful review of cost of service elements.
Thank you. I have nothing further.
Thank you.
I do have one thing further. Mr. Gorman drove from St. Louis. So if the commission does not intend to call him back, may he be excused?
Yes, he can be released once he steps down.
Thank you.
Thank you. All right. Seeing nothing additional, Mr. Gorman, you're finished on the stand. You may step down.
Thank you very much.
Thank you for your testimony. With that, all right, we're nearing 11 o'clock, so we've been going almost 2 hours. We've gotten through 2 witnesses. We've got 2 left. I think what we're going to do at this point is just give everybody a 10-minute break, actually a 9-minute break. We're going to break until 11 o'clock. We'll be back in here to reconvene. We're now off the record.
It's a big job.
Okay, so it's-
So, the first thing I'm gonna do is
We're not alone. Mine
Please be seated. All right, before we go back on the record, I'm just looking at our schedule, and we've still got 2 witnesses. But the plan is to push through both those witnesses before we break for lunch, just so everybody can plan accordingly. So we are now back on the record, and we will turn to the Citizens Utility Ratepayer Board. You may call your witness.
Thank you, Commissioner French. I'll call Andrea Crane. I believe Andrea's on the Zoom link with us. But ask that she be
Yes.
sworn in.
Good morning.
I need to swear you in. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Good morning, Andrea.
Good morning.
Could you please state your name and your business address for the record?
Yes, my name is Andrea Crane. My business address is 2805 East Oakland Park Boulevard, Fort Lauderdale, Florida, 33306.
By whom and in what capacity are you employed?
I'm employed by the Columbia Group. I'm president of the Columbia Group, and I was engaged for this case by the Citizens Utility Ratepayer Board.
Are you the same Andrea Crane who caused the filed 67 pages of pre-filed direct testimony on August 29th, 2023, and 20 pages of testimony in support of the unanimous settlement agreement on October 3rd, 2023?
Yes.
Are there any changes you'd like to make to your testimony?
No.
If I were to ask you the same questions today as you had in your testimony, would your answers be the same or substantially the same?
Yes, they would.
Thank you, and I tender the witness for questions from the commission.
Thank you. Well, we'll begin again just with commissioner questions, and I'll begin with Commissioner Keene.
Thank you, Chair French. Good morning, Ms. Crane.
Good morning, Commissioner.
Ms. Crane, I found the discussion of the settlement terms included within your pre-filed testimony to be very helpful. It was also largely self-explanatory. As a result, I appreciate very much your appearance here this morning, but I have no questions for you.
Okay, thank you.
Thank you.
All right. Commissioner Keither, do you have any questions for Ms. Crane?
Not at this time, but I also would like to thank you for the testimony you put forward, and I agree with Commissioner Keene. It's very self-explanatory, so thank you very much.
Thank you.
Well, we want you to answer something. Good morning, Andrea. Nice
Good
to see
morning.
you.
Good to see you.
Well, I want to give you an opportunity to answer sort of the same line of questioning that I asked both Mr. Ives and Mr. Gorman about some of the shorter amortization periods and the upward pressure that may put on rates. And maybe if you could just generally tell me from a residential small commercial perspective, how do you view the trade-offs of maybe getting those credits earlier versus maybe longer term rate stability concerns? Any general thoughts you can give me on why you found the approach in the settlement to be just and reasonable?
Sure. Well, I believe as Mr. Gorman indicated, there's a couple of sort of general policies that should be considered when we look at amortization periods. One is how long did the deferral accrue? Over what period of time were those costs deferred? And then, as he indicated, another sort of common thing that we look at is how long do we think it will be between base rate case filings? I think in this case, with the case of that we're faced with now, COLI is sort of the elephant in the room. And I think it would have been, this would have been an issue regardless because of the size of this. I mean, you're talking about essentially what was a $40 million credit to ratepayers in the test year. And so I think any proposal that anyone would have made, would have had perhaps a more significant impact than we are used to seeing when an amortization generally ends, an amortization period ends. The number is just so big that no matter what we did, it's going to have a significant impact. I think what's good about the treatment of COLI here is that essentially it will resolve this issue going forward. And so, even though staff and I, for example, had relatively similar numbers for our proposed rate base adjustments for COLI, we had arrived at those numbers in very different ways. And I actually had not proposed a way to kind of wind down the COLI. Staff did, but our numbers were very similar. But in this case, we can put this issue behind us once and for all. Sure, I am always concerned about the impact on ratepayers, but that was always going to be a problem with regard to the COLI. We will be looking, hopefully, at significant new revenue sources, over the next couple of years for Central in particular, and perhaps that will help to mitigate some of that impact. But, I always share your concerns with regard to rate impact because that, especially as the revenue requirement witness, that's kind of what I'm focused on.
Yeah. And similarly, I guess I always try to ask the question a little different, but maybe looking on the bright side of things, that $96 million credit, would it be inappropriate for me to think of that as really funds that were supposed to be credited to past customers? And so it may have been appropriate for that all to have been credited immediately. But what the settlement does is try to have a little bit of stability in spreading that out over 3 years. Is that an okay way to look at it?
I think that is a reasonable way to look at it. In terms of the amount, that was a negotiated figure, but there was certainly consideration of what ratepayers were promised, or at least what they were told was likely to be the benefit of COLI when the COLI was first established, 40 years ago. So I think it is reasonable to kind of get those funds back, over that period of time, or at least over something that approximates that period of time. I will also tell you that amortization periods for several of these amortizations were very hotly contested in negotiations. And there was a lot of give and take with regard to some of the amortization periods. So I think that also has to be considered when you're evaluating the settlement as a whole.
Thank you. Appreciate the answers. I don't believe I have anything else. Let me just turn to my fellow commissioners to see if they've developed anything. I'm not seeing any hands raised, so I think commissioner questions are complete. Mr. Love, do you have any redirect for your witness?
I do not.
Okay. All right. With that, Ms. Crane, we thank you for your time, and you may virtually step down. Thank you.
Thank you. Thank you.
All right. We have now come to our last witness, and this is for KCC staff. Ms. Mazantine, you may call your witness.
Staff calls Justin Grady to the stand.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Mr. Grady. Could you please state your name and business address for the record.
Good morning. My name is Justin Grady, and my business address is 1500 Southwest Arrowhead Road, Topeka, Kansas, 66604.
And could you please state your position at the commission?
I am Chief of Revenue Requirements, Cost of Service, and Finance. I work in the Utilities Division.
And are you the same Justin Grady who caused to be filed settlement testimony in support of the agreement on October 3rd, 2023?
Yes, I am.
Do you have any corrections you wish to make to that testimony at this time?
No, I do not.
All right, and I believe that Ms. Kafer already admitted that testimony into the record, so I will tender the witness for commissioner questions.
Thank you. Well, again, we'll go directly to commissioner questions, and we'll begin with Commissioner Keen.
Thank you, Chair French. Good morning, Justin.
Good morning.
Just a few questions for me. Let me just start with a process question. I think through the cross-examination of Mr. Gorman by Mr. Zakura, he brought out the sheer volume of materials that it was incumbent upon all parties to this proceeding to deal with, and in no small measure, the KCC staff. Were you here for that, for his testimony?
Yes, sir.
Can you give us just some idea? I have a pretty good idea that there was one heck of a lot of input and analytical skill that was addressed by the staff towards the issues that were presented here. Can you give us a bit of an overview of the amount of time involved in that and the degree of effort it took to try to coordinate that?
Yes, I can. Thanks for the opportunity to do that. So this was obviously a major rate case. It was something that myself and the people that work in my section and in other sections in the Utilities Division have been aware of and preparing for in some form or fashion for 5 years, right? So it's I don't think it is overstating it to say that it's the most impactful, important rate case that I've worked on in the a little over 20 years that I've worked for the KCC. And when we had internal meetings and our staff meetings, I made sure that everybody that reports to me understood that, right? Everybody knew how important the case was and took it very seriously. The amount of effort and work that went into the case by the people that I supervise was unbelievable. I can't tell you how proud I am of those people and how proud I am to be associated with them. The number of 70-hour work weeks that was put in, if I tried to estimate how many, I'd probably underestimate. And a lot of those hours of work weeks are uncompensated from an overtime perspective. These are salaried people, right? But they were highly motivated, heavily motivated to get it right, right? We didn't, as you know, we're analysts or we're not advocates. So our interests in a case like this is to make sure that we get the right answer, that the commission has the data and information and exhibits and testimony that it needs to make the right decision. But it's no, insignificant undertaking to do that, right? So I think we issued almost 600 data requests in this docket, and I don't think we've ever had a case before that I've worked on where there was more than 400 issued. So, it was significant. It was a significant undertaking. I think that's probably about it.
Well, I thank you very much for sharing that. I think it's most important. I think you have justification to be proud of your staff. I think it's somewhat apparent to me that the interveners, I think, generally shared the opinion that was expressed by Mr. Gorman about the level of professionalism that you put into that effort. And toward that end, as a commissioner, I thank you as well for that effort. Two more questions for you, Justin, and I would appreciate your embellishing these answers and giving some granularity to these questions because they're somewhat general, but I think they're pretty significant. Initially, of course, Evergy proposed its request for a rate increase in both of its Kansas service areas. Subsequently, the KCC staff conducted a detailed financial audit of Evergy's income, its revenue requirements, its expenses, and determined and indeed recommended that Evergy's proposed rate increase be substantially decreased. Now the commission has before it, for our consideration, a unanimous settlement agreement. So with this backdrop in mind, my question to you is this. In what significant respects is the settlement agreement at variance with the KCC staff's initial proposals in this rate case?
Yeah, so definitely a good and fair question. I would say generally a good place to start that evaluation would be referring to page 35 of my testimony in support. You know, if you've read these testimonies before, and I know you have, we take a pretty similar approach every time we write testimony in support of a rate case settlement, in that and this is a level of transparency that probably makes some people, you know, uncomfortable, but I always want to make sure that the commission understands at least what our view of the settlement is and what we think the big concessions are that were made in order to arrive where we are. And I think this is an important view for the commission because we take it very seriously that if we're going to settle a rate case, we want it to be very close to what we think the result would have been if we litigated, right? That's always our North Star. And so first thing we always do is say, we try to take ownership and be upfront about any errors that were made in our direct filing or updates that we made, you know, computational data entry type issues. And so we always present the revised litigation position of staff. And so if all the discussions had fallen apart at the 7th day or whatever, and we were here for a full week litigating this case, then, you know, then we would have filed revised testimony and settlement schedules for Central with $112 million rate increase, base rate increase before the effect of the offsets with the production tax credit offset and with the property tax surcharge offset and the RECA. And that's just because we did have a couple of computational errors in the Central case, and then Evergy was able to convince us that they had put some additional plant in service in the intervening time between when we filed direct testimony and when they filed rebuttal. And so, you know, we were at $112 million increase from our revised litigation position. And then, you know, by virtue of the way the settlement is constructed, there are some quantifiable areas of movement, so to speak. So, the settlement agreement includes recovery of the Persimmon Creek wind farm on a 25-year basis, levelized revenue requirement, and staff's recommendation was based on a 30-year revenue or 30-year life. And so, and then, you know, there's probably some difference in the cost of capital components that were originally anticipated in our original filing and what was ultimately agreed to by the parties. And so, you know, my quantification of that is $714,000. And then there's a difference in the resolution of the company-owned life insurance plan that the other witnesses have discussed. And so that can be quantified at $7 million. And you go down that list, and that's my view, our view, staff's view of how the settlement agreement differs from staff's filed position. And, as is always the case, there is a bucket, there's a component, there's a line item there that says unspecified revenue requirement movement. And that's just that element, that's the black box element of a settlement that sometimes makes commissions uncomfortable. And so what I always try to do is present that, compare that to what the result could have been, and talk about how much of staff's case was potentially at risk. And I did that in the following paragraphs, right? So that's for Central. For Metro, the Metro discussion starts on page 36. For Metro, we originally filed for a net, or a gross revenue requirement reduction of 42 million. There are a few more line items there, specifically for computational issues or specific updates that we agreed to make. So if we had agreed to litigate this rate case, we would have been at a $38 million base rate reduction. There's a number there for capital structure and ROE, and I did that again just out of pure maximum transparency. The words in the settlement agreement are what they are. There's not a capital structure or a return on equity explicitly agreed to in the settlement, but there's an after-tax rate of return that's identified for regulatory accounting purposes. And from my perspective, I mean, it's the only weighted average cost of capital that's identified explicitly in the settlement agreement. Right? So it's about as close as you're going to get to everybody saying, yeah, that's the capital structure and ROE. And so what I've done is quantify with staff's rate base what that means in terms of revenue requirement movement. And then there is, again, an unspecified dollar amount of revenue requirement movement. So I hope that that approach, provides some comfort or at least an analytical framework to evaluate, how from our perspective, how we think the settlement agreement compares to our filed position. I guess one other quick thing, there were a couple of charts that I added on page 41 of my testimony in support that sort of shamelessly stole tables out of the settlement agreement, or that was an Evergy work product, and used the edit text feature of Adobe Acrobat and added a line that just inserted where the settlement was relative to the parties' direct filed positions. And I think that also does a pretty good job of illustrating where the settlement landed and how close we were to the lower end of the spectrum, so to speak. And it's obvious that there are major significant elements of the settlement that were not supported by a lot of the other parties, or that were taken directly from our filed position. Persimmon Creek and Jeffrey 8% are one of those. But yeah, that's probably the best job I can do at a reconciliation between our original file position and where we ended on the settlement.
Well, that's very helpful, and I appreciate your spreading it on the record here this morning, because I think it provides perspective. It shows what the delta was, the change between your initial position and where you ended up in concurring with the settlement agreement. That's very helpful. One other line of questioning, Justin, and that's it for me. Were you present this morning when I cross-examined Mr. Ives?
Yes.
I want to follow up and ask you one bit of that line of questioning so that you can answer it. I thought he did a splendid job of answering for Evergy, but I would appreciate your take from the staff's point of view. And that question is simply this: given the bifurcated nature of the process we have before us here with these two entities for some purposes being treated quite independently, for others not so much so, my question to you again, and embellish this to the extent you can, what steps do you think can or should be taken to reduce or eliminate the rate-related disparities in treatment and outcomes between Evergy Kansas Metro and Evergy Kansas Central, prospectively?
Well, prospectively, I'm not sure. I'm pausing because I'm not sure that there are a lot of additional steps that can be taken or that should be taken, at least by staff or by the commission. And I say that because the reality is, as Darren did a great job of explaining, the reality is that it took us over 100 years to get to where these companies are in terms of, their formation, the infrastructure investments that were made to serve their customers. There are elements of it of their geographic customer density and just the nature of their service territories that are always going to persist. There are always going to be differences. Now, I think what has happened historically is the cost of service for each of those operating utilities, like we go back and look at Westar North and Westar South, the old, KP&L and KG&E service territories is, I think the costs of both of those service territories is managed somewhat independently until fortune happens to occur and they're both relatively close, and then everybody seizes on that opportunity. You do an evaluation of in the future, well, what's going to happen in the future, or is one going to go vastly different from the other? No, it looks like they're both going to move about the same. All right, let's take that opportunity and bring them together. That's pretty much what happened. It took 20 years, Dr. Glass always reminds us that there are examples of mergers that have occurred and the rates were never brought together. Midwest Energy is a good example of that, right? They still today, I believe, or at least the last time I heard, they still have two separate service territories and two separate rates. So I don't know. There was a lot of work that was done in this case to bring about alignment in terms of tariff structures and definitions, and we definitely made a lot of headway in that regard in this case. Even little things like the calculation of their transmission delivery charge, and that's not little, it's seemingly little. Wording and definitions in their fuel clauses. There's just so many things that have to accomplish, that have to occur in order to bring two, the state's largest two electric utilities into one, and then to have rate parity. So I don't know. I think just time, unfortunately, I think time will address some of it. I'm sure the company is thinking about it. There's probably always some degree of subjectivity or flexibility inherent in the utilities capital planning processes. So to the extent that they have the ability to take capital investment decisions in one fashion or another, to continue to allow one utility's rates to moderate over time and another utility comes up. I don't know, you want to be careful. I think, you definitely don't want to provide, to put too much pressure on the utility and say, within 10 years, these two rates are going to be together, because at the end of the day, customers in Leawood, have a certain system and assets and power plants and wires that have been built to serve them, and customers, and that's different than the system that was built to serve customers in Hutchinson. And especially if we have to raise the customer rates from somebody in Hutchinson and lower the rates from somebody in Leawood in order to bring them together, that's just not going to be acceptable politically or from a customer perspective. So I think we just need to keep our eye on the prize and be mindful of it, but also be, evolutionary and instead of revolutionary in that regard. Hopefully it doesn't take 20 years, but the only other example we have did. So
I appreciate very much the candor of those insights. It's really quite helpful to me, and I think probably to the public at large, to understand how truly complicated the dynamics of all of this really are. And so if I can use a really poor metaphor, I think you're suggesting that to have perfect planet alignment on this subject is very difficult.
it's very difficult. And just one more quick thing, I have this conversation because my sister and mother and my wife, my household are Evergy Central customers, and my stepdad for that matter, and then my best friend from high school is an Evergy Metro customer, and so universally you get this question of what's going on? Why are we getting a rate increase and they get a rate reduction? And it's just the nature of the businesses. It's a function of the investments that are in place. It's a function of the type of power plants that are in place to serve these different customers. And another factor as well that I don't think's been discussed, at least today, is the merger was obviously very, very beneficial from a customer perspective, in terms of rate credits that went back and mitigating rate pressures in the future and everything else. But Metro and its customer base is a beneficiary to a certain extent of timing and good timing with regard to that merger. So right before that merger closed, they had just completed significant customer service information system upgrades and very significant information technology upgrades. And Central was right about to start its upgrades. And so, a portion of the synergies that have occurred and the cost reductions that have occurred are occurring from taking advantage of a system that was already there. Instead of building another $400 million system, taking advantage of the system that was there and spreading it out over the rest of the state and using it to serve the other 700,000 customers in the state that are now served by this Evergy entity. So that's not that's a benefit that has accrued to really both sets of customers, if you think about it, and Central is now picking up some of those costs that were previously borne by Metro, but they're not picking up as much cost as they otherwise would have if the merger didn't occur. So there are elements like that are that were apparent to us as we really dug into the numbers. And then, Darren did a good job of describing the historical item resolutions that Central faces that Metro didn't face. One that he did not mention was the wholesale power agreements that have expired. Central for many years has had and still does have, but it's somewhat of a declining number now. They have had significant wholesale customer unit participation contracts and wholesale customer revenues that existed, that were there, that acted as a rate credit and it otherwise offset what retail customers were paying for service. And this is a different day and age. Those customers have different options and market access than they used to have. And so there are elements of those credits that are going away, and Metro's credits for the most part went away many years ago. And so that's an issue that sort of a headwind that Central and its customers are facing, and Metro is not. And so there's probably at least 10 more individual company by company, reasons why the result of this case is different for those two utilities, but it's, there isn't anything nefarious or untoward going on. It's just the reality of a cost of service, fully regulated business. At the end of the day, the prices customers pay are very closely tied to their actual cost of doing business.
Well, thank you very much for that elaboration. It's, it provides a great deal of insight and perspective. I'm grateful for it. I have no other questions, so I'll conclude with a comment, which I think I'd be remiss if I didn't make this comment. I want to thank you personally in this forum for all the service you give to the state and to the Corporation Commission, for your efforts specifically with respect to this matter. And with like effect, my gratitude for all of those staff members within the Utilities Division who've reported to you and contributed to your work product in this instance. I thank you for that very much. No further questions. Thank you.
Thank you.
Commissioner Keither, do you have any questions for Mr. Grady?
Yes, thank you. I too would like to state my gratitude for making me drink from a fire hose. But certainly the time you took with me to bring me up to date on what was going on was greatly appreciated. I have a son that lives in Johnson County, Leawood, Kansas to be exact, and who's been saying, Mom, Mom. And so I appreciate your general response to, increase and decrease in the two different areas. Makes it very clear and very easy to understand. My question is really just to, Mr. Ives really did a good job of speaking about time of use ideas and thoughts going forward. And I just wondered if you had anything to add to that. Thank you.
Yeah. I think from staff's perspective, I didn't disagree with much, if anything that Mr. Ives said. We've been following the media response and the customer response and the legislative response to what's occurred in Missouri, and it is what it is. But it's obviously there's a significant number of customers that appear to be unhappy with being forced onto a particular rate structure. I mentioned members of my family, so I guess I'll mention this one too. My stepsister is an Evergy customer, Evergy Missouri customer, and she had a particular Facebook post about a week ago that it went something like this. It went something like, what's going on, Evergy? Now I have to do a spreadsheet in order to just figure out when to do my laundry. I'm a single mom, and this is so complicated. And I only mention that because she was expressing outrage, or she was upset at who? Not the Missouri Public Service Commission or the legislature. She was upset at her electric utility. And so, of course, I did not engage in that discussion on Facebook, but I called her and I said, well, they actually originally requested that be voluntary and that be optional. And it is voluntary and it is optional in Kansas. And I don't see that changing anytime soon. That's the conversation that we had. So I just know that, and that's not to say that there's not merits to moving in that direction, maybe as quickly as we can over time, and as technology allows for it and customer adoption and acceptance allows for it. But at the end of the day, everything we do is a democracy, and I just don't know that customers would be accepting of that sort of a dramatic, sort of radical shift and requiring everybody to shift all at once. It's just, I don't know, like a lot of elements of this business, the rate structure that we have, the cost structure, the history of these companies, it goes back several decades, many decades, since to make that shift all at once in a mandatory fashion is, I'm not sure that's the best approach. So I'm not saying that it'll never change, but I don't think I'll ever recommend that it change to be anything other than voluntary, optional, and maybe moving customers in that fashion as quickly as possible.
All right, it looks like it's down to me. I don't have a lot for you, Mr. Grady, but I obviously asked a question of every single witness about sort of the shorter amortization periods and the cliff or the upward pressure that's going to put on rates in about 3 years with those amortization periods. And would just like to get your perspective on, when you looked at the settlement, why you thought that particular result would be just and reasonable.
Yeah, thank you for that opportunity. So we did have a range of positions of amortization periods in this case, right? We had some of the industrial interests recommending a 2-year amortization period, and then we had the companies filing a 4-year amortization period, and I think our recommendation almost universally was for a 3-year amortization period, maybe except for our COLI credit amount. And so the settlement ended at 3 years. There's a couple of specific thoughts. The reason I'm not overly concerned about the amortization periods is, I don't think 3 years could be fairly characterized as being an accelerated amortization. 3 years is very right in the middle of the fairway in terms of, the expected time for a utility to file a base rate case. If you look at their historic, base rate case cadence, especially Westar, they had a case in 2005, 2008, 2012, 2015, 2018, and KCPLs would be somewhat similar to that. So I think 3 years is a reasonable middle ground type of an approach. I also think that in this case, you'd have to go back quite a few years, I think, to find, I can't really remember one where a utility requested a increase of $14 a month for a residential customer in a base rate case, right? This we've talked about, this was a big case, and there was 5 years in between the last base rate review and this one, and there was a significant amount of investment in utility infrastructure in that period of time, and customers were facing a somewhat significant rate increase in this case. And so we sort of leaned on those amortization periods as a mitigating factor to help, to mitigate what customers would potentially experience coming out of this case. I guess the comforting thing is that their next rate case, I don't think anybody expects it's going to be 5 years, right? So I hope it's not 2 years. We like to, we make it publicly known as often as possible. As you know, we like to encourage utilities to manage their base rates at least 3 years. That's just, you get much shorter than that, and customers really do not like that. And now you're looking at full general rate cases less frequently than every 3 years, and it just seems like all you do is just do rate cases for this utility. So I think 3 years is a reasonable time frame, but on the other hand, we should not face at the next rate case, hopefully it's 3 years from now, we should not face the kind of rate pressure that customers did in this case, or because there was 5 years between cases. And so that should be somewhat mitigating or comforting in terms of what are we facing in the future. And then, a $30 or $35 million cliff is not, when you're talking about for Central, which this is, that is a relatively small percentage of their total base rate retail revenue, right? Those kind of numbers sound very large, but I don't know, I can't recall right now what their total base rate revenue is, but there are changes in fuel and purchase power expense that go up and down every year, well in excess of that, right? So I'm only sort of, I don't mean to diminish the impact of a $30 or $35 million rate increase, but relative to everything else that changes in a year with this company's retail rates, it's, the Winter Storm Uri, for instance, for Evergy Kansas Central, they had amongst the least impactful impact of any other utility in the state, as you know. I think that was a little over $100 million impact spread over 2 years, and that was $2.82 a month for residential customers. So that's going to fall off, and the run up that we saw in natural gas prices and wholesale power supply costs in 2022 would have been close to $100 million. So I don't want to diminish it, but I also don't want customers to fear that there's this giant rate increase coming in just a few years. All other things being equal, I don't think it'll be that impactful.
It's a good explanation.
Thanks.
I don't believe I have any more questions. I'm just seeing if we've got anything here. I don't think we do. Any redirect from staff?
No redirect.
All right. Thank you for your time, Mr. Grady. You may step down.
Thank you.
I'm looking around to see if we've got any hands waving with any urgent additional matters we need to cover, and I don't see any. So this does conclude our hearing in docket number 23, EKCE 775 RTS. A commission order in this docket is due by December 21st, 2023. And with that, we are adjourned. Thank you.